Town Hall, we're going to talk about the landfill litigation. Some of you, I see a few faces that were down at the Town Hall last night. We're going to go through some history of the litigation because I think you have to understand how the litigation has progressed to understand where we are right now and where we're going to be going in the next few weeks or months, depending on what happens. So with that, we're going to start talking about the Waller County Pintail litigation. This was a lawsuit that was filed in 2013, and it was filed to invalidate the 2013 ordinance and the host agreement. So let's first talk about the parties, the plaintiffs. One of the plaintiffs was a group called Citizens Against the Landfill Hempstead. Citizens group that was formed to oppose the landfill and fight the landfill. Okay. The second plaintiff was the City of Hempstead. Okay. City of Hempstead had an issue with the county basically drafting or amending the ordinance and zoning landfills within their ETJ, and we'll get to that in a second also. The defendants, Waller County was a defendant, okay? All the members of the Commissioner's Court at that time were named also in their official capacities. Not individually, but in their official capacities. And then Pintail was also named as defendant. Pintail is the landfill group that's trying to get a landfill into Waller County. So, let's talk real quick about the 2013 ordinance and the host agreement. What are these items? 2013 ordinance. Basically, when this landfill became public around June of 2011, shortly thereafter, Commissioner's Court, within a few months, drafted and passed the first landfill ordinance. Okay, this was in 2011. I refer to it as the Monaville ordinance. But basically what it said was that you cannot build or operate a landfill within 2-mile radius of any existing landfill or previously permitted landfill. Now there is a landfill in Monaville, Bestpac, that was closed some 20-25 years ago. My understanding is there are a number of landfills around the county, some near Prairie View. I can't tell you, and maybe other folks can, whether or not those were permitted or not. But anyway, the main thing was that it drew the circle in Monaville. Now, the landfill application, the landfill company had already filed their application with the TCEQ, or parts of it, I should say. They had filed what's called a bifurcated application, which means they filed parts 1 and 2 of their application prior to that landfill ordinance being passed, and then parts 3 and 4 after that landfill ordinance was passed. About the same time, that was the 2011 ordinance. So then you fast forward, and in 2013, in February 2013, Commissioner's Court passed an amended ordinance. And what they did is they amended that previous 2011 ordinance and instead drew a circle, basically right here, a small circle, around the Pintail landfill and said this is the only place in Waller County you can build or operate a landfill. At the same time, they entered into a host agreement with Pintail. This host agreement was a very large document, 60 plus pages, very complex, had a lot of things in it. It had tip out rates that were going to be paid to the county and to the municipalities for every ton of garbage that was going to be put into this landfill. I believe there's documents that show that over 30 years, these payments, depending on, if you take 7,000 pounds or whatever it is, that 7,000 tons would have yielded somewhere in the neighborhood of $52 million over 30 years to Waller County and the municipalities. It also provided for other things like providing land for a new fire station, providing a recycling center, providing money for scholarships, providing money for salary for a grant writer. There are a lot of things that went into this host agreement. Okay, that was executed between Pintail and the county in February 2013. Shortly thereafter, this lawsuit got filed, okay? And it was filed in March of 2013, and it was set for trial in December of 2013. Shortly thereafter, in October, Judge McCaig recused himself. Apparently he had come across, or during the process of the litigation, I think there was an admission that he had read some information or seen some information outside of court, and therefore he felt it was best if he recused himself, and a visiting judge, Terry Flanagan, was assigned. So we had a visiting judge that was put on the case. Then there was a conflict. The county's attorneys had a conflict, and so then they rescheduled the trial from December 2013 to July 2014. Before we got to that trial setting, I believe, Pintail filed a motion to transfer venue. This was supported by an affidavit of Frank Pecluda, who was commissioner at the time. Basically, and what Commissioner Pecluda was saying in his affidavit is that he did not believe that there could be a fair trial obtained in Waller County on this issue. I actually at that time I did an affidavit of my own that was actually filed on the response, because at that time I had been going through both a primary and I was engaged in a general election. And I knew for a fact there were a lot of people in this county that knew absolutely nothing about the landfill. And so I was confident that we could find 12 impartial, fair jurors from Waller County to hear a case about Waller County, and especially about our Commissioner's Court. That trial got postponed because of that motion. So again, they postponed the trial because of the challenge. They had an evidentiary venue hearing in July of 2014, and that motion to transfer venue was subsequently denied. Trial was then rescheduled for December 1st, 2014, and jury selection was scheduled to begin in mid-November. A jury did get picked. They sent out juror notices. They had a huge pool, 2 days of jury selection, and they found what everybody agreed was going to be a fair jury for this trial. Then, right about that same time as they were picking the jury, Waller County filed a mandamus and an emergency motion to stop the trial. And basically what they were asking, and this, for those that don't know what a mandamus is, that's where you're asking an appellate court to order a judge to do something in the lower court. And in this case, the county had filed what's called pleas to the jurisdiction. Basically, they were saying that the district court did not have the jurisdiction to hear some of the claims and issues. So they were saying, and the judge would not rule on that because he felt that there were certain facts, testimony that needed to be had before he could rule on that motion. So they filed this mandamus, and they were basically wanting that judge to be ordered to rule. On the next day, November 14th, Cal responded to that emergency motion. Then same day, City also responded. 3 days later, Cal, and keep in mind we're working up against a December 1st trial date. Cal and the City both also responded to the mandamus which had been filed. On November 21st, so basically 7 days after the mandamus and emergency, the Court of Appeals denied the mandamus. And I'll tell you, at this point in time, a lot of people were kind of surprised because they pretty much figured once you've got a mandamus filed, it almost acts as, it's almost going to probably postpone the trial. Because it's very rare that the Court of Appeals responds that quickly. They typically will take it under advisement, and the trial kind of gets postponed. So it can be, now I'm not saying they did it as a tactic to delay, but it often can be used that way. Waller County then on 23rd of November, they appealed that decision of the Court of Appeals to the Texas Supreme Court. And they filed an emergency motion to stop the trial. On November 25th, Hempstead responded to that mandamus at the Texas Supreme Court. And on November 26th, the Supreme Court, this is the day before Thanksgiving, again, amazing, the Supreme Court denied the mandamus and emergency motion to stop the trial. Also going back on November 23rd, 2014, Waller County had also filed a notice of appeal with the Court of Appeals. And again, there was a motion to dismiss that appeal. November 26th, the Court of Appeals, so you had appeals at the state Supreme Court, and then they also initiated additional appeals. Again, this was all gauged to try to postpone the trial, stop the trial, because they felt there were legal issues that had to be addressed. November 26th, Court of Appeals dismissed Waller County's appeal again and issued a mandate allowing that trial to go forward. November 27th was Thanksgiving. Then on the eve of trial, December 1st, right as we're about to go to trial, Waller County then filed an emergency motion to enforce a statutory stay with the Court of Appeals. So now this is basically appeal number 6. And then on the same day they filed it, the Court of Appeals denied that emergency motion. On December 3rd, so that was the 5th one. Now we're on 6th. December 3rd, Waller County filed another appeal to the Supreme Court regarding that motion to dismiss. And on the December 5th, Supreme Court again denied to take Waller County's appeal. So 6 different appeals, 6 times that the Court of Appeals and Texas Supreme Court said no, you're going to trial. So the trial lasted 10 days, cumulative, over 2 weeks, but it was kind of broken up. These are the witnesses that were called by the different parties, and I apologize if this is small for everybody to read. I'm trying to work with the logistics here. So we got Citizens Against the Landfill that called Mike McCall, Glenn Schenkel, Frank Pokluda, Judge Beckendorff, Debbie Holland, the county clerk, and Bill Hunsinger. Hempstead, you only had to call Mayor Wolf. The county called Debbie Holland, Commissioner Kitzman, and Commissioner Barnett. Pintail never called any witnesses. I don't think they even made an opening or a closing statement as far as that matter. The trial lasted over 10 days, over a 3-week period. There was a middle time where the judge had a conflict, and so there was like a 1-week break in the middle. And then the jury verdict returned. The jury verdict was returned on Friday, December 19, 2015, after deliberating about 2 hours. So, what was specifically the jury verdict? What did the jury find after listening to all the evidence over a 10-day period? First, they found that Waller County Commissioners Court deliberated non-legal matters relating to the ordinance 2013 ordinance in a closed meeting. Okay, that has to do with the Open Meetings Act. Anytime that you are going to discuss public policy, it must be in an open meeting. It must be done with notice. It must be posted. It must have an agenda that gives people enough specific notice that they understand what the conversation is about. If you are going to use executive session, you can only do that in certain instances. For example, to discuss personnel matters, to discuss pending litigation. You can use it to discuss the negotiation of a contract. But when you do so, you must enact a very specific provision of the Open Meetings Act that then allows you to go in executive session. Because there are circumstances in which sometimes you have to negotiate those contracts in executive session, otherwise you lose leverage, and it's difficult to have to come into open court every time and vote on what your new position is as you go back and forth on a contract. But that did not happen in this case. Also, when you go into executive session, those sessions are supposed to be recorded in some way, shape, or form. Okay? That also did not occur. I will tell you now, when we go into executive session, every executive session is tape recorded. So that if there's ever a question on whether or not we're discussing public policy in executive session, I will give the tape to a judge and I will let the judge listen to the tape and he can make that determination right then and there. It doesn't require testimony. The next thing that was determined by the jury was that the Commissioners Court deliberated non-legal matters relating to the host agreement in a closed meeting. They also found that at least 3 members of the Commissioners Court engaged in a walking quorum related to the host agreement and the ordinance. Okay, again, and I'm sorry if some of you know this already, I'm just trying to make sure everybody understands. Walking quorums. Walking quorums are illegal. You cannot use walking quorums to get around the Open Meetings Act. You know, if I go to Commissioner Barnett and I say, hey, do you like this ordinance I drafted? I think it's a pretty good ordinance. What do you think about it? And he says, I like it, Trey. I think it's pretty good. You're going to vote for it? Yeah, I think I would vote for that. Okay, great. And then another meeting, I walk up to Commissioner Beckendorff and I ask him, I say, what do you think about this ordinance? I think it's pretty good. What do you think? And he says, it's great. You're going to vote for it? Yeah, I think I'll vote for it. Okay, I've just broken the law. I have basically engaged in a discussion in separate meetings with a majority, with a quorum. And we've already made a determination as to how we're going to vote on something. So that is a violation of the law, walking quorums. The next item they found was that Commissioners Court negotiated the terms of the host agreement and ordinance before presentation to Commissioners Court for a vote. And that there were committee meetings related to the host agreement and ordinance that were not open to the public. Okay? The jury also found that the vote on February 13, 2013 in open court was a rubber stamp of the ordinance and host agreement. Again, rubber stamp is a legal term. Again, if you go and you work out all the details and you get everything worked out in closed meetings behind closed doors in violation of Open Meetings Act, and then you walk in and you put it on the table and you go, okay, we got a host agreement. Is there a motion? Second? No discussion? It's approved. That's a rubber stamp. Okay, also against the law. And then finally, the jury found that Judge Beckendorff, Commissioner Kitzman, and Commissioner Bakluta failed to comply with the Texas Public Information Act. This one is a pretty broad. Texas Public Information Act, unlike the Open Meetings Act. Open Meetings has to do with public business being discussed and how the notices have to be posted 72 hours before the meeting, specific enough to give you notice on what we're talking about. Public Information Act has to do with open records. So if you make a request, if you want a copy of certain emails or you want a copy of documents, then Public Information Act governs how those requests are treated. There's notices that are supposed to be posted at the courthouse. That's one of the issues they had. They weren't posted properly. There's certain deadlines that have to be complied with, in which once you get a request for public information, you have 10 days to basically either respond or request an opinion from the Attorney General as to why you're not providing those documents pursuant to that request. Do we have any empty seats? We got a few people out there in the hallway. We got our Constable Herschel Smith here. So if we can make room for those folks. So there was not in the jury question. It actually listed all the different types of ways you can violate the Public Information Act, and all they answered is that it was violated. So we don't know specifically. It could have been something as simple as they didn't have the notice posted on the wall outside of their office, or it could have been something else. So that's what basically the jury verdict said. So that was in December. Where do we currently stand? Well, right now we have a hearing that's set for February 20th, and at that hearing the judge is supposed to consider motions for entry of judgment. All the parties have filed motions for entry of judgment, and they're all asking for a wide variety of things. One of the things that Cal and the City of Hempstead are seeking is an injunction that the county officials have to comply with Open Meetings Act. They also want to seek findings of fact. This is where you're asking the judge to make basically written findings where he decides based on the jury verdict and the testimony, these are the facts as determined by the judge in the case. So these are the findings of fact that they are requesting. 1, that Waller County violated Open Meetings Act related to the ordinance and the host agreement. 2, that the meeting notices for December 19th, January 2nd, and February 13th, 2013 were not specific enough under the Open Meetings Act. Oops. Now I got to go back. Next, that Waller County failed to follow Section 5510725 of the Texas Government Code and committed illegal acts by discussing non-legal matters in a closed meeting. And that the Waller County Commissioners Court committed illegal acts by engaging in walking quorums in relation to the host agreement and the ordinance. And that the vote on February 13th was indeed a rubber stamp. They also wanted findings of fact that Waller County committed illegal acts by violating the Public Information Act, that Waller County violated the Texas Health and Safety Code when it passed the ordinance and host agreement. Now what is this about? Texas Health and Safety Code, basically, I believe it's chapter 364.012. That's basically the part of the Health and Safety Code that allows a county to regulate landfills within the county. Okay, what they are alleging, and what the City of Hempstead is basically, what they are alleging on their side, is that us as the county did not have the right, legally, to regulate a landfill inside of Hempstead's ETJ. So what happened was, again, going back to when the 2013 ordinance was passed, 4 days prior to that ordinance being passed by Waller County, City of Hempstead went in and annexed Frazier's Concrete. Now at that point, and does everybody know what ETJ is? Extraterritorial jurisdiction. So it's that area, it's an area that's determined by population, and it goes beyond your city limits, but it's an area in which the city can start putting in regulations and codes and so forth. so that when they go to annex that property, it's not, way out of whack. So anyway, my understanding is Hempstead's ETJ at that point actually did already cover a piece of the property where they are proposing to put the landfill. But when they annexed Frazier's Concrete, it basically covered it. And the City of Hempstead put Waller County on notice prior to the landfill ordinance being amended. And they basically said, if you even think about amending the landfill ordinance and zoning landfills into our ETJ, we will file a lawsuit. And sure enough, they did. So that is one of the issues that City of Hempstead was seeking. And again, this is finding of facts that they're asking for, that the county can prohibit disposal of waste in the county under certain circumstances under the Health and Safety Code, but that authority does not extend to a city or a city's ETJ. Okay, they're asking for this in the form of a declaratory judgment. Again, this is where the judge makes a declaration of law, and they're making a statement. The county has no authority to do X. This is very important. I want everybody to remember this part because we're going to come back to this in just a second, because I'm going to tell you why that is a very dangerous proposition for us right now in Waller County. Also, they are requesting a declaration that the ordinance and the host agreement are void. They're asking the judge to void those. And they want a permanent injunction against Waller County from designating any area of the city or their ETJ as suitable for a landfill, or doing a host agreement with any entity that regulates or licenses a landfill inside of an ETJ. And also they want an injunction that the Waller County Judge and Commissioner cease and desist from violating Open Meetings Act and Public Information Act. Damages. Under Open Meetings Act, if you prove a violation of Open Meetings Act, you are entitled to reasonable attorney's fees. These are the attorney's fees that City of Hempstead is seeking from the judge. $272,000 and some change against Waller County, $70,000 against Pintail, and then $60,000 if there are any appeals all the way through the Supreme Court. And just so, let me stop right there for a second. I want everybody to know I am limited. What I'm going to do tonight, everything I'm discussing is information that is in court documents, is in pleadings. I cannot discuss with any of you anything that's taken place in an executive session or anything that is a matter of settlement negotiations. I can tell you where we all are as far as what we filed, and obviously a settlement is going to be, if we're looking at a settlement, we're trying to get something that's between the extremes. This is what Cal is looking for in attorney's fees: $350,000 and some change against Waller County, $114,000 against Pintail, and $115,000 for any appeals all the way through the Supreme Court. So if you take out the attorney's fees they're seeking against Pintail, what they are seeking, they're asking the judge to award attorney's fees against Waller County of close to $800,000. Now, attorney's fees at Pintail, you see where I have on here, attorney fees that Pintail could seek from Waller County, approximately $150,000. To date, Pintail has paid $150,000 of Waller County's attorney's fees in relation to this litigation. There is an additional invoice for $172,000, which has been presented to Pintail, but has not been paid. Now, this is pursuant to the host agreement, which requires Pintail to reimburse the county for its attorney's fees. Okay. Now, if the host agreement is voided, whether it's by agreement or the judge voids out the host agreement, then I would expect that Pintail is going to come back and they're going to be looking for their attorney's fees. And they're going to be doing that under a theory called quantum merit, which basically if you advance money to somebody, you're expecting a deal, there's an understanding on what you're supposed to get in exchange, and then that deal doesn't happen for any reason, you get your money back because you didn't get the benefit of the bargain. So I would expect that we could be looking at another $150,000 in exposure from Pintail. On January 12, 2015, Commissioners Court voted 3-2 to agree to the invalidation and voiding of the host agreement and ordinance in keeping with the jury verdict. Okay.